Hi, good morning, everyone. I'm Carolyn Beneglauda, the Programs and Outreach Manager at Southeastern New York Library Resources Council. Thank you for joining us for today's webinar, which is New Laws in the New Year. Before starting the program, I'd just like to do some housekeeping. Because of the overwhelming interest in today's webinar, we have over 200 people registered. We are using Zoom webinar. That means that only the presenters and the hosts have microphones and cameras enabled. So you as participants can use the chat, and we encourage you to introduce yourself to others right now and just make sure that your comment is going to everyone and not just the panelists and hosts. If you have a question during the meeting, please use the Q&A feature rather than the chat. We are anticipating a lively chat, so if you have a question that you don't want to get lost among the other comments, make sure to use the Q&A feature, and that way we can also mark off things that have been answered by our host today. This webinar is scheduled to run until 11:30, so there should be plenty of time for questions during and after the presentation. And we might, if we go over a little bit, we might hang out for a little bit after that. We are recording, so if you miss anything, you can catch up on the recording. Just so you know, Zoom offers automated captions. To view them, click on the Show Captions icon on your Zoom screen, and then click on the caret to view more options. All attendees are expected to follow Southeastern's Code of Conduct, which will be added to the chat shortly. In short, please treat all staff, event attendees, and speakers respectfully. Those who do not adhere to the Code of Conduct will be removed from the meeting. We are recording today's event, and we will make the recording available to you as soon as we can upon the webinar's conclusion. We'll send you that link, and we will also send you a form to evaluate this discussion and a request for a certificate of attendance if you need one. We'll also share a link to the other webinars that Cole is hosting for us in 2025. I'll be here in the background throughout the meeting. I'm also joined by my colleague, Susan Detremont from Capital District. So please contact either one of us through the chat if you need any kind of technical assistance. And with that, I am happy to turn our webinar over to Stephanie Cole-Adams.
Thank you, Carolyn. Hello, everybody. Good morning. I want to add one other thing about asking questions. So I'm just mindful that sometimes you might feel constrained asking questions in a public forum. So if you'd like to ask your question a bit more discreetly, I believe you can select either Kirsten or Brian and send them the message privately, and they will jump in and ask it. And that's if you just don't want to be identified with your question. I don't know why that might be, but if it's a thing for you, by all means, please do that. So thank you. I'm honored to be here with you today, coming at you from Buffalo, New York. I'm an attorney who loves working with libraries, and my part of my team is here because they love working with libraries too. So without further fanfare, we're going to get into new laws in the new year being 2025. We are here in this time, in this place. Which of course, when I pitched this to ESLN and we got it on the calendar, it was kind of like new laws in the new year. La, 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 right? And now, Kirsten picked this picture out. I believe this is like a human record scratch, right? By Moreau. And, right? So we're gonna acknowledge the elephant in the room before we jump into all these other great things that are on. If you didn't have a chance to download and either print or access on a device today's learning checklist, feel free to do that. I would be very remiss if I didn't just say there are some new executive orders in place. I forced myself to read all of them the other night while my daughter was at karate class, which was kind of a cathartic place to read a bunch of new executive orders. For today's session, when there's an executive order that I think pertains to the content that we already had planned to review, I will speak to that. However, yesterday I spoke with ESLN about would it be helpful to generate a resource to go through the executive orders, not just with respect to the employment law and DEI initiatives that may be affected, but there's also some things I noticed that could impact how we gather and access and display information, and how as libraries, museums, library systems, et cetera, might be thinking about not only your employees and the community you serve, but the actual the work you're doing. So Nathan and I are going to be spending time going through that. And if you have questions about a particular executive order, I'm going to encourage you, you can, let's see here, you can send that to Nathan at the LOSA, and I'm just going to put that up there. So if you also have read the executive orders and you have a question, we're going to be creating an Omni resource because we're just going to stay calm, but obviously make sure we're being as careful as possible with this development. So you can send the questions. I'm going to be working on that over the weekend. And you can send those questions to Nathan at losapllc.com. You can pop them in the chat and we'll try to inventory them. But honestly, it would be, if you can funnel them that way, that would be helpful. Or if there's a resource you'd like to consider. And I will mention there's already some great resources out there. Of course, the ALA has resources with respect to visits from immigration authorities at public libraries. And the Council of Non-for-Profits has also put some guidance out there. So these slides will be available. I'm sure you've got the skills to find these links. But we will be doing something that's really customized for cultural organizations, 3Rs, library council served organizations here in the state of New York. Because as we're going to be talking about throughout this session today, New York is a bit special. We've got our own human rights laws. So we're going to talk about that. And then that resource should be out by Tuesday. And if you keep an eye out for Ask the Lawyer, that should be out there. And again, this is an all hands on deck. I invite input, comment, etc. So elephant addressed. Moving on. There we go. Okay, so we're going to talk about
Sorry about that.
So yes, so we have one thing that is expiring. I mean, this just seems like so 2020 at this point. The various COVID sick leave laws that were enacted in the New York State budget are going to be coming to an end on July 31st, 2025. There's been a lot of confusion out there about these laws, and by no means do I think that the couple slides I have on this are going to clear that up entirely. The current obligation has been for certain organizations to provide additional sick leave for COVID leave when there's a quarantine order in place. From what I've seen, different municipalities and different employers are interpreting that differently, and that's okay. And it'll be all over by July 31st. If you want to just check in on what had to be done, right? There were some rules for small businesses with 10 or fewer employees, medium businesses. We had different rules for large businesses and different rules for public employers. All of that is going to be over as of July 31st, 2025. But the important thing is, of course, if someone is out sick, they're out sick. And whatever leave that whatever sick leave that your institution offers and whatever policies, obviously being ill and out for COVID or isolating. So for instance, I recently had COVID, yay me. January 3rd, boom. My husband got it too. And my husband's employer actually has policies above and beyond what's required by law. So they actually didn't want him to come back to work for the 10-day period, which is an older period, but that was their policy, and that's fine. So each of you, if you are the library leader, if you're setting that policy, you can certainly go above and beyond. That is down to how you want to set policy. But as far as the mandatory, that'll be coming to an end. And of course, that was something that gets tripped when there is a mandatory order of quarantine, which generally is not happening at this point. But every county health department is different, so I would never say that it's simply not happening at all. We're going to move on past COVID and go on to some other things here. So we've got self-insurance for certain public entities. This is a pretty esoteric thing. We're not going to spend a lot of time on it, but if we've got folks, I think we do have folks here from cooperative library systems and certainly from municipal libraries. So certain entities are now going to be able to basically work together to self-insure, and more so than in the past. For those of you who don't deal with insurance at all, this is your chance to check out and take a sip of coffee. But it is an interesting thing if you are part of a group or if you lead a collaborative initiative, taking a look at the change in the law and seeing, would this enable us to do something a little bit different with respect to self-insurance? Not going to spend a lot of time on that, but it's, again, something I want to raise awareness about because it's a possibility that could be both empowering and save money for certain types of institutions. So I'll leave it at that. If people have questions on that, you can send that in, but taking a look at changes in self-insurance for New York State is something you could follow up on. Then we've got newish. So regarding civil service disability determinations. So this is an amendment to the New York State Civil Service Law. This really has to do with, for those of you who are civil service employees or running a civil service compliant organization, certainly the municipal libraries who are in attendance, under Section 72 of the Civil Service Law, if an employee is becoming, I'm going to be very careful here, becoming unable to do their job, and it's suspected that the reason might be related to actual capacity related to a disability, there is a process under the law. And I have to say, using this process, you should always be guided by an HR expert or an attorney if you use this process. There is a process to have them evaluated if that employee is simply not able to self-disclose or confront that, right? And of course, employers cannot say, oh, I think you have a disability and you're incompetent to do your job. So the civil service law does provide for that. And the law was recently changed so that when there is documentation generated per that process, that employee is entitled to it, which I would have thought would have been the case anyway. So that seems like a really good adjustment. I'm putting this out there because it's a fairly recent change. And also I think this is something that is potentially underutilized or there's not a lot of awareness that this is an option. But again, I just want to stress if utilizing Section 72 of the Civil Service Law is something your library leadership would need to do because there is a concern that relates to performance and suspected disability factors that relate to it, plan that out very carefully. It is not something to simply dive into. And as the change to the law shows, be ready to make sure that that information that is generated is shared with that employee. And yes, I've got the caveat on here now, right? Important, don't start it without getting, or your civil servants agency, although the level of help that we get from local civil service agencies varies from agency to agency. Is that a fair assessment, Kirsten? It changes? Yes.
County to county.
County to county, exactly. City to city sometimes. Okay, this is something that was new as of September 2023, a little bit old, but it's just something that I think some folks are still struggling with implementing. So this is just the requirement that for all employers, so everybody who's participating here, doesn't matter what type of institution you're at, unless you're employed out of state, that's different. But if you're leading an employer in New York State or you are an employee, anytime employment is terminated, whether it's due to a resignation, a layoff, a termination, a retirement, no matter what, employers have to provide a record of employment form. The form is right there at the link. It's a very simple form, but in New York State, anytime an employee is terminated, they do have to get notice of the effective date of the termination. Again, for whatever reason, whether they rage quit or quiet quit or are terminated, no matter what the reason is, they have to get a letter saying, yep, you've been terminated. Your last date of work was this date. And now an additional form, the link is right there. And it's really just notifying them that they may be able to apply for unemployment. Well, they can apply and they might get unemployment. It doesn't guarantee them that they have unemployment coverage or that they will get the unemployment coverage, but it's a notification of how the process works. The state did this because they were finding that people who were entitled to apply for unemployment and to have that type of protection simply were unaware of it. And so this has been the reaction to that. So just for those of you who are supervising, if you have a sort of a termination template you use, adding this form to it, along with if you provide health insurance, of course, a COBRA notice this is an important thing. And for those of you who are, not supervising and are employees, this is something that if you quit and move on, your employer will be providing. Oh,
Cool.
yes.
We had a question. Does the record of employment apply if the employee goes out on paid leave?
No. So usually when an employee goes on paid leave, and of course, paid leave does not have one legal definition, but generally when an employment is on leave, they're considered to still be an employee. And of course, there's depending on the type of employer and the employment arrangement and the policies, when an employee is on paid leave, for instance, they may still be covered by the employer's health insurance if that's an option. They still might be tallied in a calculation of employees. It's really going to, it does depend on the circumstances. But until the employment is actually terminated, there is no obligation to provide the form. So yes, so if they're on paid leave, whether it's covered by FMLA or it's sort of an approved period of unpaid leave, there's no need to provide the form at that time.
I
Yes.
have some more questions. You had mentioned retirement and it doesn't seem to fit this.
So, well, no, retirement, anytime an employee is done, is terminated, even for retirement. When it says, congratulations, you're retiring effective January 29th or whatever, this letter should accompany as well. Yes.
Even if the employee quits on their own.
Even if the employee quit, as I said, even if whether they rage quit or quiet quit, they have to get this notice. Yes.
And what kind of proof needs to be kept that they provided this paperwork?
Oh, that's a great question. So a really good practice would be, of course, saving a copy of the termination letter, which is the termination letter is either we're so sorry you had to go, or, maybe it might say you didn't show up to work. We waited 3 days. You abandoned your job and, your last day was this date. And then it would say enclosed, please find the record of employment required by New York. And for those of you who are visiting the site of the form, you'll see it's a very simple form. And then simply saving a copy in whatever way you choose to send it. Usually I prefer emailing it and sending it good old fashioned USPS is fine. And then save a copy to show that it was provided. And
someone pointed out that this also might be valuable documentation for people who the question was the comment was in Q&A and it just disappeared on me.
Sorry, that was me. This might also be valuable documentation for people who need to provide proof of employment for something like public service loan forgiveness long after their agency is defunct.
Oh, that's an interesting point. So yes, I mean, it can be used potentially as lateral evidence and all sorts of things. So absolutely. So it's, there's a way there's certain documentation that just should be generated as part of when an employee stops being an employee. And no matter what has ended the employment relationship here in New York, this form should now be a part of that. So, and I'm guessing because we're getting some questions that, I was thinking, I was like, oh, people have been doing this since September 2023. Do I really need to include this? I'm thinking maybe it's helpful that it's still there. So, but we will definitely get the slides out. People will have that, and the link is right there for you to find that. Anything else on this one? We good? Okay, there we go.
Yep. Would this apply to students who are on work-study jobs?
I'm going to say yes for now. I will take a look. Brian, if you can make a note, we'll take a look if there are any exceptions, but I don't believe there are exceptions. So I'm going to say yes. Yes, whether they're in temp employee, any type of category of employee that's coming in. It doesn't apply to independent contractors. We're going to talk about independent contractors in a little bit too, but it does apply to temp employees, including students. Yes. So this is a new one here. I think this is probably not going to be a problem. Oh, sorry, for most of you, because in my opinion, my experience at least, most cultural institutions kind of get this as a matter of respect, but there is a new law. It did go into effect March 12th, 2024, Labor Law 201I. Employers cannot request access to personal accounts and devices, right? So Here we go. This is a really good reason. You see the practical implications here at the bottom. This is a very good reason, not that we needed another one really, to minimize the use of employee-owned devices and accounts for business purposes. For those of you who are at libraries who are subject to FOIL, Freedom of Information Law, there was already high motivation to make sure that if employees are expected to use technology as part of their job, if they're expected to have a tablet, a laptop, cell phone, it really should be either issued and owned by the institution, or there should be a very clear policy about how the employee's personal technology is being used by the employer. I have very strong feelings, and they are feelings, not legal advice, that employers should not take advantage of their employees' personal devices, just as sort of a baseline human decency. But sometimes, even for the convenience of the employee, sometimes that employee may want things coming to their personal cell phone because, frankly, it's just easier for them rather than, having two phones. It is possible to do. I've worked on policies like that. There's some great models out there. I'm sure you guys can share some information about that. So it can be done, but just this law here, Labor Law 201I, is yet another reason why when it is done, it should be done very carefully and per policy. And whenever it can be avoided, it should be avoided. So just I'll pause 1 second and see if we got anything on that. But
someone commented that their whole county uses two-factor authentication, which can rely on personal cell phones.
I'm being recorded, so I'm not going to criticize the county, but I don't know. I mean, so using the cell phone to help with two-factor authentication is different than actually storing the personal information on that particular device. But I definitely, again, I would avoid that as well. But sometimes the practicalities of the situation and even the equities of it can be arranged so that the personal device of the employee is used. It can be done, and it can be done properly. It's just there should be a clear policy, and definitely they are out there, and it is done successfully. So, but it should not be a gray area. Okay. So I mentioned we were going to talk about this, the Freelance Isn't Free Act. So interestingly, this isn't new. However, it was changed. So it was passed with a flurry of fanfare over a year ago. And as it had been passed as part of the labor law. And then it was pointed out that the labor law primarily covers employees, which specifically independent contractors, freelancers, are not. And so everybody sat back and thought, wish we'd caught that sooner. They didn't. And then they went ahead and took the chunk of law that had been in the labor law and put it verbatim into the general business law, which is where it belonged. It was like a homecoming, right? This is where it always belonged. It did not change the expectations. So for those of you who are familiar with the Freelance Isn't Free Act, it was another one of those instances where the state, particularly Department of Labor and the Workers' Compensation Board, as well as the courts, we're seeing a lot of instances where freelance folks were, I'm just going to say it, being taken advantage of. And maybe some of you out there who have, done some gig economy stuff, have noticed this. It happens in both the profit and nonprofit sector, and it can be a real scourge. So this law was passed to say, look, when someone is providing their services as an independent contractor, there are certain things that must be in the contract, or the employing entity, right? The person who is the entity that's being served will face fines and penalties. This applies to everybody, all employers, all people hiring. So if here in my law firm, if I hire an independent contractor, it applies to me. If the Buffalo and Erie County Public Library hires an independent contractor, it applies to them, right? So it doesn't matter whether it's a small firm, big entity, government entity, et cetera. If an independent contractor is being hired, these contracts must now meet the requirements of the Freelance Isn't Free Act. And as you'll see here, it has certain requirements, including that there's a written contract, timely payment, a copy of the contract must be retained for at least 6 years. For those of you who are following the LGS1 document retention schedule that governs municipal libraries and other government entities, you're doing that anyway. And it has the penalties for noncompliance. So handily, and I love the I really do appreciate the Department of Labor. Just we are your DOL. You know, it's that they know how to do branding, right? So they have provided, and the link to this form is right there up at, you know, the URL is right there. And they have provided a, get ready, 6-page template for people to use to meet the requirements of the Freelance Isn't Free Act. Now, as they point out in their guidance on this form, this isn't everything you might want. So for instance, when I work on a independent contractor agreement, there are times that we're going to want representations about insurance, indemnification, certain qualifications. So you might want more in a contract with an independent contractor. But what the DOL has done with this form is say, here is a form that meets the baseline requirements of the law. So it's a great place to start. So for those of you, this is particularly important, you know, for the audience here, if you get a grant and you are bringing in an independent contractor in to fulfill the terms of the grant, maybe you're going to create a new mural, maybe you've got someone who's going to do some workshops for your library, using this template is a great place to start. Again, if there's additional expectations and risk management, insurance requirements, safety requirements, things like that, you would want to have an overlay, but this is the bare minimum right here. And it's important, and it's now in the general business law where it belongs. Do we have a question?
Yes. Would this law be true for performers we use? I know
Yes.
most libraries don't use a contract for this.
So that is a great question because it gives me an opportunity to say, particularly for performers, because performers are one of the categories of workers, performers, artists, creatives, are one of the categories of workers that they were really seeking to protect. So if you take a look at this law and you look at the memo that the state assembly had when it passed the law, which the memo that goes with legislation is the why. Why did we do this? It really talks about how very often creatives can end up being exploited, frankly, or payment is delayed. And it can be tough because, of course, sometimes grant payments get delayed. So if you have if your institution is hiring someone to fulfill the terms of a grant, and that grant is being paid to your organization on a reimbursement basis, and your library doesn't have the liquid cash to make sure that the payment goes out promptly to the performer even before the reimbursement comes from the funder, that can be a problem. What I will say is if we have any library trustees who are listening, or trustees in general, that kind of need is why your library should have a fund balance, or your institution, your museum, your archive, etc., should have a fund balance. And part of the fund balance should be to provide liquidity, right? So that you can pay the artist even before the funding for the grant comes in. It's just, and it's one of the, I'll go on a soapbox for a minute. It's one of the problems with some of the models for grant funding out there is that a smaller institution might not have the capital to advance the monies that are going to come from the grant. That is a problem that the board of trustees, the board of directors, needs to solve with budgeting. It is reason 101 why you have a fund balance. Well, it might not be reason 101, but it's definitely in the 100s level, right? Of why you run a fund balance. And for municipal libraries out there, if you are running into trouble with your municipality trying to claw back your fund balance, which is a problem that we're seeing a lot these days, being able to pay your contractors before you get grant money coming in is one of the many, many, many reasons why you should have a fund balance policy and tell the municipality to do something when they try to take your money back. I'll leave it at that. So I know I just daisy chained a lot onto that, but these things are all connected. But at the end of the day, oh, go ahead. Go ahead. Yep.
We have several other questions. And if I miss your question because it's in the chat, I'm very sorry. The chat is scrolling farther than I can get to. Do we need a contract if the performer invoices us?
Yes.
Okay.
Ooh,
And author visits too, if we pay a fee?
yes.
Yes. Does the contractor have a responsibility to provide a contract?
There is a responsibility, there's an obligation to have a contract. The responsibility is not on the service provider, no.
Okay. Would this need to be renewed annually, say for a graphic artist who we have used for a couple of years?
Actually, that's a great question. So for those of you who have some frequent performers, definitely putting in place a contract and then using a statement of work that refers to that contract every time, that's fine. That's completely fine. The point is
Okay.
that there's clarity. Yeah.
What if the person you're contracting with has an LLC or other formalized company structure? Does that mean you're paying the company rather than an individual?
Ooh, interesting. Yes, it does. Yes, it does. LLC structure is different. Yep.
Okay. Saw another one. Can contracts be scanned and stored electronically? 6 years is a lot of paperwork.
Yeah. Yes, they can. Yes, they can. Absolutely.
Okay. Do friends groups also need contracts for speakers and performers?
So if the friends group is actually doing the hiring, whoever is doing the hiring and making the payment, and I appreciate that sometimes maybe the library would make the arrangements and the friends group would pay, but essentially it's whatever organization is going to be responsible can be the one that has the contract. So that can be, there needs to be a contract, and remember that the contract is assuring accountability for payment. So whoever is responsible for payment ideally is the best entity to be there. However, if you're also using your contract, so if the event is happening at the library and you're using the contract to not only set the terms, but to maybe set some terms regarding safety, and things like that, it might be better that it be in the name of the library and the friends provide the money to the library and then the library pays it out. Kind of like a micro grant.
Right. So to clarify, if they are an LLC or something else, do we need the same type of contract with them?
That is a very good question, and I will have to look that up. So Brian, can you make a note of that and we'll adjust, we'll get that out there.
Thank you.
Yes, thank you. I want 3 more stumpers before we get through all the slides. The challenge on. All right. We're all in the same boat. Okay, another newish one is Pay Transparency Act. I'm not going to spend too much time on this because I'll spend a little time. I think this one is old hat at this point. This is only for New York State businesses, private businesses with 4 or more employees. Employers must provide job descriptions and list the compensation range and designated job, anytime there's an opportunity, whether it's a job opening, a posting, a promotion, or a transfer, they have to make that information available. And this is especially association libraries, private museums, etc. For the attendees here who are at the quasi-governmental, the municipal libraries, etc., all of the information, this type of information can be gathered through FOIL. So this law didn't apply. It really goes after the private employers who before this could have kept that information private. And of course, the memo that went out with this law was saying that secrecy was being used to potentially exploit people or pay them less, right? Pay one person less than another person for doing the same type of work. So this is about equity.
We had a follow-up question. Do we need a contract in addition to this agreement? This is on the previous.
Oh, on the previous one. So, whoops, well, we'll stay here. So what the state has provided is a contract. So that is a contract, but if there's additional terms that you want to enforce, then there should be then you need to have additional terms, either adding it on, and you can do that through an addendum, or just having your own custom contract that you make sure has all the things that the state has put in the model. So yes, it's always, and it's best to have, you can do, like I said, you can do that either with one contract or one contract and an addendum. You just want to make sure everything harmonizes really well, so it doesn't look like there's two separate contracts that kind of are at odds with each other.
Okay, and for the Pay Transparency Act, does it have to be posted internally, or can it just be on an external job board?
It has to be available. So if there's an internal inquiry, even if it's on an external job board, the question should be answered, and it can be answered by providing the link, right? So the answer, if the question comes in and says, well, what's the pay range? The answer from HR, from whomever, could be, we've posted that right here. You'll find that information right here, and that's fine. So, but it just needs to be available.
Thank you.
Yes. So now we have the lactation law, right? All employers must provide a space for paid breaks to express breast milk. And whenever an employer has to let people know that they will do this. So I think we have plenty of information. I mean, we don't need to spend a lot of time on this one today because the state of New York has provided a wealth of information on this right here at this link here, including some model notice language and all of that. And including addressing things like, oh, what if we don't have enough room? How do we get this notice out? What do we have to do? So, and the frequently asked questions are truly, this has been in place for a bit, so they've really gotten some good questions. So I just encourage folks to take a look, because at this point, Department of Labor, they're on this. So we can spend a little time if people have questions, but I would defer to the excellent materials that are right here at this link. At this point, for those of you who have employee manuals, this should be in the employee manual. And the policy in your employee manual should be informed by the content here, and also the notice, how you're letting employees know that they have this right and how your particular workplace is living up to this. That should all be in writing. There should be no gray area. And if you follow the steps that are at this website provided by Department of Labor, they'll get you there. It really will get you there. So I can answer questions, but honestly, it's literally all right there. And I don't say this often. I could not say it any better than they did on this website. So there's my little bit of my ego for you, but it's excellent. So I would just say, take a look. If there's questions afterwards, you can certainly send them on in. And I would encourage you, if you have questions that they haven't answered, send the question to Department of Labor, because what they've done here is they've put together a really helpful resource.
Link in the chat.
Yes, thank you. And if employers are not doing this, the Department of Labor does want to hear about it, and there's a place on that same excellent website to file a complaint that this is not being provided. New York is really trying to bolster a lot of what I guess what I call family-friendly, parenting-friendly legislation and regulations, and this is just a small part of a big effort. Speaking of which, prenatal leave. Now, this only applies to private institutions, so association libraries, private museums, private archives. If you are a quasi-governmental or institution like a town library, city library, etc., it does not apply to you, although it's good to recognize that this is going to become probably another sort of done thing in the state of New York. So this is prenatal leave. This means that all employers must allow up to 20 hours per year of paid leave for prenatal care. This is in addition to any unpaid or paid sick leave or paid family medical leave that is already being offered. So some of you may recall that if you are subject to the paid sick leave law in New York, this applies to the same employers, association libraries, etc., private employers. If you're small enough, if you're under 5 employees, you do not have to provide the paid sick leave. However, no matter what size of employer you are, if you're a private employer, you have to provide these 20 hours for prenatal care. And so this is an important one because this does offer paid leave even for smaller employers who haven't been required to provide the paid leave. Went into effect January 1st, 2025. So I appreciate that not everybody who's in attendance today has to worry about this one, but it is something that should be in place if you are at an association library, again, no matter what the size. Any questions on this one?
Question.
Yep.
If a local government opts out of this, is it a violation of the new amendment that prohibits discrimination against pregnant people?
Oh my goodness, that's a great question. So a local government, because this law does not cover government entities, there's no opt-out from this one. So there's no local option on this law because this law only covers private employers. So, and when I say private employers, I really mean the cooperative library systems, association libraries, a not-for-profit historical society, a not-for-profit corporation, a museum that's not regarded. So some museums are municipal entities, but most are not. Most are private. So most of the museums who would be a 3 Rs member, but and hospitals kind of all over the place. A lot of hospitals are municipally owned and this will not apply. So this isn't, don't leave this one to chance. Checking in with your lawyer, with your local HR provider, just to make sure. But in general, if your institution doesn't follow New York State's paid sick leave law that was passed a few years ago, this is an add-on to that. So if you don't have to follow that, then you don't have to follow this one either. But as with all things legal, check with your lawyer if you can.
Someone asks, we cap the number of hours of paid sick leave that can be used in a year, and I assume these 20 hours cannot count against that tally of paid sick leave used.
So this is where it's really important to think about the type of organization, because if your library is a private, and if your institution is private and has to follow this law and has to follow the paid sick leave law, the paid sick leave law doesn't allow a cap on accruals. It does allow a cap on use, but exactly right. This would be in addition. This is a completely different kind of leave. It's in a completely different bucket. So.
And would this cover someone who wants to use the time leading up to birth, i.e., their due date is January 31st, and they want to take the 20 hours before their due date?
So this is for prenatal care, and we are still awaiting regulations on this. So we might be getting, as they say in my biz, further and better particulars. Right now, to me, prenatal care is care that is you're working with a provider for care related to pregnancy. So if it's taking additional time off to rest, because that has been what's been recommended and is required, then yes. But I would just say, I'll say this. Let me back away just a tiny bit. So whenever an institution is addressing someone needing to be out for medical leave, that should be for whatever reason, right? That's time for really careful attention to all of the different policies that and laws that your particular institution has to follow. I've done some presentations for ESLN before where I've talked about the continuum of leave, because there's a continuum of leave, and on that continuum of leave can sometimes be disability accommodations that might require someone to start working part-time for a while. It would be potentially a Family Medical Leave Act time, which is time when your job is protected. You're not necessarily paid for it. It might include a period that's covered by New York State disability insurance. It might cover some other type of time out covered by policy or a union contract. It's very important. So I always like to do this by FAQ. So every institution, every employer should have an FAQ saying, well, what if I need to be out for disability accommodation? What if I need to be out for prenatal care? What if I need to be out for maternity or paternity leave, parent leave? What if I'm adopting a child? What if all of this? Your policies and your manuals should speak to that. And I know ESLN has some materials that I presented last year that we can pull out and refer to on that, because it's important that it was a great question that was asked. It's really important that all these different kinds of leaves and all the different rights and legal obligations are assessed properly and documented properly. I know that I probably didn't make anybody feel any better by saying all of that, but it is important. So, but it can be done.
Are municipal libraries considered public employers?
This is a really delicate question. So most municipal libraries are, for purposes of the labor law, and bear in mind that different parts of the labor law actually apply to different kinds of employers, including government employers, depending on what section of the labor law we're talking about. It's very frustrating, very, very frustrating. But for purposes of the sick leave law, the New York State paid sick leave law, they have been considered to be public employers. Yes. But that means that all your employees should be getting the benefits of being public employees, comp time, et cetera. That they should either be considered to be public employees. A good litmus test is, are you following civil service? If they're civil service employees, then they're also public employees. And that's a good starting ground. So for those of you, especially the association libraries who are not following civil service, do not have to follow civil service, you are private employers. So that's a litmus test, but I would say anytime you're in doubt, making sure you get confirmation from an attorney in writing and make sure that attorney has malpractice coverage so that you can really stand by what they say. That's important. Don't just get casual guidance in line at the grocery store. So.
Question. Did you say that private institutions cannot put a cap on accrual of sick leave?
Correct. That is the law. I knew someone would pick up on that because that's always a thing. Yeah. We will send out
Okay.
information on that. But yes, since the paid sick leave law was adopted, you can put a cap on the amount of hours used in a year, up to you can't cap lower than 40 for most institutions, but you cannot put a cap on accruals, bearing in mind that there's no requirement for there to be a payout of the paid sick leave. So again, and that's only for the private employers.
Okay. What if a person is able to do their work from home while a family member is undergoing something like cancer treatment? Do we need a policy for that, or can we just accommodate it internally? This is for an association library.
Oh, that's a great question. So, anytime someone is working remotely, it should be per a policy that's in place. So if your institution has adopted a remote work policy that includes people can work remotely, just as part of normal business, that's fine. If someone is working remotely and that is an accommodation for them, let's take it this way. If it's an accommodation for their own either disability, that should be per an accommodations letter, not your policy. If they're being asked to do, if you're making an ad hoc modification because it's for their family, and the person's not taking a leave, which they might have a legal ability to do, but instead you're changing their job conditions, that should be really well documented in a letter. And it should be, and just some care should be taken. I would say, if at all possible, work with an HR specialist on that kind of thing, because you don't want to say yes to one person and then no to another person and have that resolve into an accusation of unfair treatment. So I think just approaching it with caution, but it can certainly be done, especially if it's if you want to use that as a retention tool to make sure you hold on to and are supportive of a great employee who's a part of your community. Absolutely, it can be done. It just should be documented properly, not done casually. Okay.
Thank you.
You. We got okay. All right. Everybody, this is one I really do. This is pay attention time because I personally think this is very, very important, particularly for our frontline library workers. So this is a change to the workers' compensation law regarding stress-induced injury. I don't know. Do you guys know any librarians who might have some stress-induced stuff going on? Maybe, maybe. So this is a change to workers' compensation law, section 10. It went into effect a few weeks ago. It applies to all employers. So we were just talking about the distinction between private, governmental, et cetera. Doesn't matter. All employers, doesn't matter the size. Now, this is correcting what, in my mind, for a long time had been something that was grossly unfair. So I'm going to go, yay, New York State Assembly for this change. Basically, and you can read this, but I'll summarize. It used to be that if you were in a stressful profession and you have some stress-induced injury, you needed to be able to show that the stress you were enduring was above and beyond what's normal for your profession. As you can imagine, this was kind of difficult for people like firefighters, police officers, librarians, right? Because there's a certain level of stress that is part of the job. So what this law has done is said your stress-induced injury is going to be valid even if you're part of a stressful profession. This is really important. Kirsten, I love the picture you found for this. But this is really important. So I just stress-induced injury, whether it's to mental health or it's having an actual physical effect, that's just as real as if someone gets an injury because a bookshelf falls on them. Stress-induced injury, if it's diagnosed by your medical provider and it's related to, if it's caused by work, that should be documented and a claim should be filed. Now, the worker, I don't want to say that there's magic wand of you file it and automatically you get compensation and you get time off and all this kind of stuff, but it can start the process of having that evaluated. And it can be can be a valid injury. And the New York State Workers' Compensation, for those of you who've lived through a comp claim, it's not easy. It can be stressful in and of itself, but it is there for us and we pay into it. And it's important to recognize that if you have stress-induced injury, your claim might go through even if the same claim wouldn't have gone through 2 years ago. So for those of you who are confronted with that, I just want to make sure, spread the word. Wellness in your profession is a very, very real priority. It's a very real concern. And this is just another piece that we now have to work with in confronting concerns with, I guess I'll say cultural worker, library, museum, et cetera, with injury in your field. So any questions on this one? It's pretty clear. Yeah, it's pretty clear and it's good news. It's not good news that there might be stress-induced injury, but it's good.
Oh, we came up with a question. Thank you, Daniel. Are there any requirements on heat/temperature that the workplace must provide for an employee to be required to be on site? For example, a historic site, a house museum, during the winter?
We do have something coming up on that, although not quite the same thing. I don't know the answer to that question in a sort of a general. OSHA certainly has something to say about that. So it's going to change from place to place, but we are going to talk about temperature in just a moment or two.
Isn't this stress-induced thing going to affect many in the health industry?
Absolutely. Yes. Yes. It's, and again, I always talk about those memos that were passed along with the law. The memo talks about the impacts of stress on very important professions.
And another question. Libraries are very stressful workplaces. If enough of our employees go out on stress-related workers' comp claims, could there be a point where the library can't run?
So there could be. I guess I wouldn't sugarcoat that. I would say this though, um, and I'll say this to library leaders, so trustees particularly, who might be either attending or watching a recording. The conditions of safety and stress are leadership level concerns. And there are a number of things that can be done to address the particular kind of stress that might be arising in a particular kind of institution. Um, so workplace safety plans can be a big part of that. And there's a lot of great material out there on those, including from OSHA. Employee wellness, making sure people know when they can take leave, having a really robust array of policies so that people are able to take care of themselves. So there's a interwoven array of assets to address those kinds of concerns before you would come to a worst case scenario like that. Um, I'll leave it at that because I can feel myself stepping onto my soapbox. So I'm gonna dial it back. But there are a lot of things that should be done at the leadership level. They have to be done at the leadership level because they have to be budgeted for. They cost money, and at the end of the day, they probably save money. I'll just say one other example would be an employee assistance plan. So an employee assistance plan can be a great resource because it's a confidential resource for the employer to refer an employee to if they're sensing that they're having some life struggles, and it's affecting work. It can be a fantastic resource. Usual employee assistance programs cost under $10,000 a year, but when you think about what they can save in productivity and employee retention, it's worth it. But again, that has to be done as part of a budget tool that's thinking 5 years ahead. So this is the work of thoughtful trustees. And also, of course, forward-thinking library directors and leaders, right? But and other leaders. But it's a budget thing. It cannot be done by the employees alone.
We have a couple of observations.
Sure.
It isn't just employees. Directors have crazy stress. Directors may be going out.
Oh, actually, when I say employees, I mean directors. So in lawyer world, directors, executive directors, you're employees, absolutely. And so it's everybody's in this, and I guess we could say we're all in this together, or you're all in this together. And as I just said, this is not an issue that can be solved at the director level because it requires forward-thinking budgeting. It is a budget issue, among many other things.
Someone observed that EAPs are inexpensive and they've used them in every workplace for services and referrals to providers. It's a great low-hanging benefit.
Yes, yes. Thank you.
And a question, does the compensation in this law mean time off and paid leave?
So workers' compensation, depending on what the work related, it's for, so workers' compensation is for only work-induced injury or illness. And it covers time out. So if the person has to be on leave, it covers medical bills. And if there is permanent injury resulting, it can also compensate for the injury. I was going to tell a story, but I'm not because I'm being recorded. So we'll leave it at that. But it really depends on what's covered, but that's why documenting injury in the moment is so important. I know I sound like such a lawyer. Oh, someone slipped and fell, document. It is important because especially if you experience head or neck injury, something like that, you might not feel the impact of that for a while, but it could be very real and it can be very life altering. And again, in New York, we pay for these things. And trust me, if anyone wants to jump in comments and back me up, for anyone who's lived through a comp claim, I've personally lived through one comp claim for me in my life. They are not fun. They are not. It is not easy to game the system, and it's a rigorous review and it's a fight to the finish. But it's real and it can help out. And again, it covers all employees, including directors and executives, including leadership.
We have an observation that it seems that workshops/training is needed for trustees to ensure that libraries and other workplaces can function in this environment. It could be unsustainable if too many employees are tapping workers' comp on a continual basis.
So definitely there's a reason New York State passed mandatory trustee training, because awareness of all the factors that create a sustainable workforce it's important. And even if people are aware of what it is, it can't be done unless it's budgeted for. Right. It's why attention to workplace safety and risk management is so important as well. Because yes, we can't have so many people getting injured that it will simply render I'll tell you this, just I don't want to get too far in the weeds, but once a library has a certain amount of well, any employer, once an employer trips a certain amount of injury claims, that is part of the robust evaluation that we start looking into. And if the employer is actually found to be maintaining an unsafe workplace, that's a whole other can of worms. So the obligation, and trustees do have to understand this, the obligation to maintain a safe workplace, it starts with that leadership. It starts with having really solid policies and enforcing them that require, that set the stage for workplace safety. There's always going to be something unsafe that happens. We can't completely mitigate everything, but good policy, it starts with good policy and practices. So we have, this is just a shorty. I doubt any of your institutions have been doing this anyway. It's an add-on to the executive law that covers as a civil rights requirement the ability of people after a conviction to not be denied employment and educational opportunities simply on the basis of having been convicted. This law is saying that an employer cannot require an applicant or an employee to provide their criminal history. So I guess this is something that has been required by employers or possible potential employers in the past, saying, you know what? We're not going to do your background check. Why don't you send us your background check, right? Send us your rap sheet. I guess that was a thing. If your library has been doing that or your institution has been doing that, don't do that anymore. But, as I think many of you know, it is a civil rights violation. It is a legal violation to ask applicants and employees, to disclose criminal history and then to make an automatic negative determination without applying a very, very careful analysis. And that's also true if criminal background checks are being conducted. The bottom line on anything related to hiring and inquiries and examination of criminal background check is do it very carefully. If your institution does not have a written policy about using criminal background checks, do not ask, do not do them. The law is very, very clear. I think there's certainly plenty of model policies out there. We can provide a link if people need it, but it's very, very important. And so this is just another piece. Don't ask people to send in that paper as part of their application. Yeah, when in doubt.
An observation, this eliminates the criminal record, but many employers ask for fingerprints prior to hiring.
So, and some employers are required, of course, to have employees get fingerprinted as part of their, especially if you're working in a school. So yes, I'm not going to go down the fingerprinting route, but basically, the takeaway is for employers, if a lot of 3Rs member institutions don't have a large HR department to guide them through their hiring practices, but when it comes to any examination of criminal background, and some of you, of course, have positions, especially positions working with vulnerable people, children, other vulnerable people, where you want to be aware that the person doesn't have certain recent convictions in their history, whether related to violence or identity theft, et cetera. You have that obligation to make sure you're hiring people who don't have those concerns. If you're doing that, if your institution is doing that, make sure you have an up-to-date policy. It's been reviewed by your lawyer, and you're following that policy. any decision to use criminal background, just as an example of why this is important, any decision to use disclosure or discovery of criminal background of a conviction needs to be analyzed by 9 factors, and that analysis, a copy of that analysis, talk about document retention, needs to be retained by your institution, and the applicant or employee it pertains to, they can demand a copy of your analysis. And if you don't have that analysis, legal violation right there. So it's one of those things where this area is not one to wing it. Have a written policy, make sure someone has analyzed the written policy, signed off on it. It should be in your employee manual, your HR manual, and follow it.
Does this mean that those "have you ever been convicted of a felony" question aren't illegal?
So, oh, all right. Don't ask unless you're ready to ask. So I'm just gonna, for purposes of today, I'm just gonna say, unless your institution has a policy about the use of disclosure or requests or conducting criminal background checks, unless you have a policy that references the New York State executive law and the corrections law and civil rights law, unless you have that policy and it's about 2 pages long, you should not be asking anything. Which again isn't to say your institution should not be conducting appropriate background checks for sensitive hires, but there should be a policy. That's all I'm going to be able to say right now, just because I don't want to go down a road where I'm saying anything that could be misconstrued. Don't do it without a policy, and the policy should be extensive. Is that?
Yes, thank you.
Okay. Okay, so we have a new law. EpiPens in all places of public assembly. This is one of those things where the phrase public assembly has different meanings depending on which law we're dealing with. This is Public Health Law, Section 225, 5D. Went into effect in November, applies to places of public assembly with occupancy capacity of at least 1,000 people, etc. Definitely not going to include most of the institutions here, except for if we have large academic libraries, maybe on a college campus, it might apply. However, and just take heart. So places of public assembly will not include halls owned by churches, religious organizations, granges, public associations, or free libraries, public libraries in this case. If you are at a larger institution, most likely it's not going to be the library within the larger institution, again, like an academic library, that has to worry about this. So I just put this in there as an FYI. It's also just handy as information professionals and cultural workers. It's just handy for you to know that this is now a requirement. Okay. Yes.
We had a couple more questions about the background checks. Our civil service applications ask this on them. They are given to us by the county. Does this need to change on their end?
So what would be good in that case is to ask the county what is their policy for evaluating disclosures. And if they say what, then follow up. Yeah, but hopefully they have that on there because they have a policy in place to take appropriate action when it's on when they're working on coming up with the list for your civil service.
Would it be wise to have clean legal records for trustees?
Ooh. So, and by clean legal records, I suppose criminal background checks and seeing if trustees have convictions. So I want to say it this way. First of all, the policy in New York, and it's a wise policy, I think, is that once someone has been convicted and paid their debt to society, as it were, they're entitled to a fresh start. And so that's something I just want everybody to remember. There are many people who have convictions who have worked very hard to move on in their lives, and our law in the state of New York guarantees them a fresh start, with some exceptions, as we've talked about. And certainly service as a library trustee, someone who has been through that kind of difficulty actually could bring a wide range of experience and empathy to the role. For libraries that rely on their trustees to provide volunteer service, which they shouldn't necessarily, right? The role of the trustees should be to show up to the trustee meetings and conduct business as part of a group of trustees. And personally, I don't see any need for that person for a criminal background check to perform that function. Obviously, the role of treasurer, depending on the degree to which the treasurer actually has any custody of funds, that could bear some thought. However, if your institution has passed the type of fiscal policy advised by the New York State Comptroller, which really means so that no one's holding all the money at once, right? No one has the power and ability to simply go in, take all the money and fly off to Aruba, right? The fiscal policy should be such that no one person could ever do that. So personally, when it comes to fiscal security, I prefer to rely on really well-developed policy that means nobody could get in there and do anything nutty on their own, right? Rather than simply placing your trust on simply one person. That's a better way to do that. So I would say a policy of criminal background checks for trustees as a general rule, no, I would not recommend that, no. But great question. All right, so then I got a question actually about this law that went into effect on December 17th of 2024. It's Aaron's Law. It's actually the second Aaron's Law we have in New York State. So not to be confused with another Aaron's Law that was passed, I believe in 2017, that had to do with sex offender issues. And that type of safety. This Aaron's Law has to do with having Narcan and other opioid disruptors in public buildings. So I got the question, oh my goodness, this law was passed. Does this mean that all the libraries suddenly have to have the Narcan? And it comes with a training requirement that people at the public building have to be trained to use the Narcan. Now, I know that many of our attendees today, your institutions have already, this is old news to you in the sense that you've had Narcan on site and had people trained in how to use it for at least 10 years, if not more. But this is really the question of, does this new law require what has been done voluntarily? And the answer is right now, we don't know. The law was passed. It amends the public buildings law. And there's a new Ask the Lawyer coming out on this. The public buildings law is this great law that governs public buildings. It's a state law. And the different sections of the public buildings law define public building differently. That's just how we roll in New York. So a public building for one purpose isn't a public building for another purpose. That's fine. The law was passed without any enabling regulations being in place, which is pretty typical. And until we get the regulations from the state, we won't know which buildings this applies to. I keep talking about the memo that is passed along with these laws. The memo that was passed with this Aaron's Law and went into effect December 17th, 2024, says all buildings, all the buildings, mentions libraries specifically, museums, etc., without restriction to size or anything else. However, the law that this was actually passed into, it doesn't seem like the actual implementation is going to be that expansive. Will it? I do not know. We're going to keep our eyes out for the regulations, and when we have them, we will post the update on Ask the Lawyer, and we'll ask the councils to send out an alert. So that's the best I can do for today. If anyone wants to pop on and see, if you find maybe the regulations were passed on, yesterday, and I didn't get a chance to look, so feel free. And if you find something from it would be the Commissioner of General Services regulations. Put it into the chat and let us know. But otherwise, we'll be vigilant for where this is going.
On a similar topic, is there an existing law that requires public libraries to have an AED?
So, great question. This law, this Aaron's Law, is actually an addendum to the section of the public buildings law that requires the AEDs. And it's the same thing. In this case, we do have regulations, and the regulations change based on size and building capacity. So I would refer you to the State Commissioner on General Services website. They actually have an excellent, so the same way I was saying that there was really good material for the lactation law, and pointed you to that resource from Department of Labor. The Commissioner of General Services has really good breakdown of where the defibrillators, the AEDs, have to be. And so rather than me trying to remember, I would refer you to that page. If Brian, if you want to see if you can find that, you can pop the link into the chat. But I'm pretty confident this audience can also find it. So, all right. Then we've got future news. So now we're looking to the future, and we talked about temperature. I can't answer for the temperature in all the buildings at all the times, but I can say this. For those of you who are working in a school district, we have a maximum temperature in school buildings law that is going to go into effect September 1st, 2025, which means, of course, for the fall semester of the 25-26 academic year, applies to public school facilities in New York State, painfully from my perspective, except in the kitchen. I don't even know what the deal is there. But as you can see, and I don't know, I'll leave it to the chat to give some color commentary on this. So it requires the cessation of instructional activities, except for in the kitchen, whenever the temperature exceeds 82 degrees. 82 degrees. And at which time instruction shall cease and the administration needs to take action. Take action includes things like opening the window. I'll leave you can look up, so this is Education Law, Section 409N and 2801A. I'll leave you to take a look. But basically, I don't know, 82 seems real hot to me, but I'm just gonna put that out there. So this is a new thing. Obviously, because this is in the school environment, there may be many union contracts that hopefully bring the temperature down a little bit more. I don't know. So, but here we go.
And this speaks to a maximum, but not a minimum.
Right. This is just right. This is the maximum. And I'll take a look and see if there's a minimum. I did not see when I was reading, because of course when they change the law, usually they're inserting a new section into a pre-existing law. And when I looked at this, I didn't see and the minimum temperature is whatever 45 degrees, at which point action will be taken. I didn't see anything like that. But that's we're looking on my memory. I would say this in general. Because obviously this law here is confined to the school environment, public school environment. When there is a concern about too hot, too cold air quality, that is something to think about. How can we address this? And there's no one right answer, unfortunately, and especially for those of you who might be in beautiful old historic buildings with beautiful old historic insulation, which may or may not be working, HVAC systems, etc. All of that, the environmental health issues. Again, this is where looking to trustees, a facilities inventory to say, okay, what's going on in our facility? What do we know we need to work on? And there's the, well, we would love to have this, but then there's the, what are the must-haves? And this is where working for our public libraries who are on here, working with your library system to talk about construction funding for projects to make sure that you're providing a baseline of just safe temperature, air quality, working conditions. That is another thing that really begins and ends at the board level. It's not something that either the director or the other employees can tackle themselves. It's just not going to happen. So this is very much something that goes on the board at the board level. All right, we've got future new. Speaking of safety, now this probably will not pertain to most attendees, but I think it's important for, again, information professionals, for people to be aware of. And it's also a bit of a model to look to, which is the Retail Workers Workplace Violence Prevention Act. So this will only apply to, again, private institutions that have retail sales, not food, and at least 10 employees. So probably not most, again, attendees here today, but if you do have a gift shop that falls into this requirement, it's at least important to be aware of this and take steps to rule your institution in or out, your private institution in or out. And this is really about having a model of workplace violence prevention and training to address the kind of things that we know frontline workers at open institutions are facing. I'm going to point this out because it's obvious it's a requirement that doesn't go into effect until January 1st of 2027, again, for retail providers. However, it might also generate some model materials and practices that libraries, museums, and other institutions could just be looking towards. So again, and this is something that's going to become a norm in the retail environment, and it's something to look to.
We had a couple more comments about the temperature.
Oh, sure.
Is there anything about outdoor temps for library programs? And
Oh.
other than using common sense and a thermometer, does it apply to outside when holding an event or program?
Oof. That's a great question. I don't know of anything that puts a minimum on for that. If we've got folks here from the North Country, I have a feeling you're thinking, what, come on, everybody just puts on another coat. It's no problem. I've been saying that to my daughter. Having grown up in Central New York and living in Western New York, I'm like, what? It's not cold. Come on. But yes, I think my impression is common sense. I will take a look, but I will say this. So what's more important is considering having a programming policy, and there's been a lot of talk in the last few years about why it's important to have a programming policy, and having maybe a safety part of that programming policy, or having a general safety policy, because of course your events are being in part put on, but and are being participated in with the workforce, with the director, with your staff, and your volunteers, and having something for safe events that includes that, and includes who has the accountability for an event being safe. Some people, when something like an unsafe temperature happens and people have put so much time and effort into planning a great event, they don't necessarily want to be the one who pulls the plug, but there should always be clarity on where does the buck stop on pulling the plug on programs due to safety. That should be really, really clear. And it might not always be the director or the executive director. It might be a head of programs who does that. Or, playing the good cop, bad cop game, maybe it would be a committee of the board that would do that, so that no one on the staff has to take the heat for it. So there's so many approaches, but there should always be someone or a body that is making the safety call, and that person having awareness of the requirements of the general liability insurance. I knew I wasn't going to get through a program without talking about insurance. I'm sorry. Having an awareness of the general liability insurance coverage will help. Let's put it that way.
The Retail Workers Act. What if we sell used books?
So yes, and this is where I think it's just important to pay attention to this. It's not going into place until January 1st, 2027. I think so. I'll be paying attention to this. If there's a chance that it would apply, it's really with retail sales. So usually the way the books are being set up, it's not retail sales. You're probably not charging sales tax. Maybe you are. We should probably talk about that's a topic for another day. So it bears paying attention to. It really doesn't. And actually, I'll say this. So for those of you who might be considering a renovation project to add, maybe a big coffee shop where there's going to be 10 or more employees, and you're going to have that kind of, or not a coffee shop because it doesn't include food. If you're going to have those retail sales, if you're going to have a gift shop, paying attention to this and just making sure that planning to abide by this law, or maybe reducing those operations if you're thinking, uh-oh, maybe we don't want to do this. It's good to be aware.
Does the number of employees have to be those who are in the retail department?
Yeah,
Like,
that's a
you have a
great
custodian
question.
who doesn't work the point of sale.
Right. That is a great question. And we're going to need to get some regulatory guidance on that. Yeah, absolutely. So because right now it's places with retail sales with 10 or more employees, which means yes, your non-retail staff may count, which doesn't seem, on the one hand, that doesn't seem, I don't know, fair to me. It seems counterintuitive, maybe is a better word. But on the other hand, this is all about safety. So we'll have to wait and see. We don't have to worry about it until 2 years from now. But as we know, time passes quickly. So I'll be paying attention to this one, and you'll see more on it. We did get some questions in advance. We're not going to be able to spend too much time on it. It could be I know there's going to be a lot of resources coming out about web content accessibility, Americans with the recent changes to the ADA, Title II, applying. So talk about private, non-private, private and public. So for everybody, all the private employers that I was stressing out with all that stuff about paid leave and everything, you can now take a breath because these changes do not apply to you. They apply to public entities. So back over to you, municipal libraries, village libraries, etc. Now, there have been other changes to the ADA. It is constantly evolving, and so you will be seeing more about this, but the particular changes that I'm referring to here are for Title II, and they have two different go live dates. Large institutions, which are defined in the regulations, that go live date is going to be in 2026. Smaller institutions have a little bit more time to adjust, and it's new regulations for ADA compliance regarding the accessibility of e-resources. I have a column coming out in Ask the Lawyer about what this means for archives. So there's going to be a lot more coming out about this. I just encourage everybody to stay engaged because it's also just a way to make sure that your work is staying current and accessible. I mean, at the end of the day, it's about compliance, but it's about, for those of you who are working so hard to make sure that your services and your information is maximally acceptable. This is really the evolution of what's state of the art for that. There's a link to some really good guidance for those of you who are thinking, oh, I really want to dive into this. I would encourage you to start with this page right here. For those of you who have specific questions, I encourage you to share the information, send questions into Ask the Lawyer. There's going to be a lot on this, and I'm sure there's going to be a growing body of excellent guidance as these go live dates get closer. So let's see here. Oh, look at that. All right. So we're at the thank you. I'm just going to put up if you have questions on the executive orders, you can send those to nathan@losapllc.com. I'm going to be working over the weekend, looking at all the executive orders to take a look and see how will they land on cultural institutions here in New York State. So there's some great national guidance coming out, but the landscape is different in New York. Every state is different. And so I'd like to be able to get some really customized guidance out for our New York State institutions who are 3Rs members. And the more, send in your thoughts, your ideas, and always with the Ask the Lawyer resources, we don't like to be redundant. So if you see a great resource that you're just like, hey, they got this, feel free to send that into Nathan as well, and we'll take that into account. But we want to make sure people feel ready and confident with respect to some of the things that have been either directly said or alluded to in some new federal orders. So we're going to be doing that. And I'm going to kick things back over to Carolyn for the formal end, but I'm going to linger for a little bit to answer some additional questions, just for another 20 minutes or so.
The event is formally ended.
There we go.
But yeah, we'll keep it open if questions come in, and I guess we'll keep recording unless there's any reason not to, because you have given out your information. If anybody needs to ask something anonymously, they could do that. But we'll just keep this recording for posterity. And I know this came up in the chat. Just if you need a certificate of attendance, we just dropped the link there. And the evaluation form is dropped there, and we will send an email to everybody who registered with a link to the recording and the links from the program that came through as we talked.
Okay. Well, do we have any more questions?
We did have a question that I missed on the way by. It has to do with the temperature. I have a staff member that wears a wool winter hat during her shift. The library is 69 degrees. She uses a space heater. Could this be a dress code issue?
Oh, well, that's a great question. I think that before I went to dress code, I would also think about, could it possibly be an ADA issue as well? Because while of course we never, so when it comes to disabilities or possible disabilities, it's against the law to endow someone with a disability, right? Oh, you're always cold. You must have, there's any number of things that could make someone feel always cold, including just life. Um, but if someone really has that need, they might want to raise that as a disability issue. If there is a very clear dress code that has a good reason for whatever reason, for whatever reason, employees never wear hats. I don't know what that reason would be, but it's not my job to write dress codes. Actually, it is my job to write dress codes. Never mind. But as long as there's a justifiable reason behind things, that's actually, of course, gender, ethnicity neutral, all those things, right? You can put it in a dress code. Sometimes even not wearing a hat that might obscure, it could even be a safety issue, just like open-toed shoes. So if there is a very clear and enforceable dress code and wearing a hat at work doesn't work for that, isn't compliant with that, then that could be raised with that person. But here's an example of how ADA works. So if that issue is raised with that person, so going to have a discussion with you, this is the rule, you're wearing the hat, and then it comes back and the person says, I have XYZ, that means I need to wear a hat. Then that begins an iterative process where it needs to be seen if that person is allowed to wear the hat as an accommodation. And they might well be. I would say that if the work environment is within what OSHA and other agencies would say are tolerable levels of heat, and someone does need to be warmer, they need the space heater, they need that warmth, there may be a medical factor there, and that might be brought out. This is also, so when it comes to what do we wear to work, every place has a different approach. And I can't say, I'm not going to tell places, what do we want? Do we want everybody in a black shirt so that there's just a, with a badge, right? What is the look that we want to present to our community when people come in so they can identify a library worker, et cetera. Balancing that is, of course, individual expression and individual comfort. Every employer can come up with their own unique blend on that. There's no one right answer, but they do have to make sure that whatever rules they decide to enforce, that there's a reasonable basis for it. There should always be a reasonable basis, and the reasonable basis shouldn't be, we want everybody to look nice. That's not quite it. So we could do a whole session on dress code, but I would just say, working with someone just to gently say, here's our defensible dress code. It's very well thought out. We stand by it. You're not abiding by it. If that person says, and this goes on the flip side, if you're at a work environment where there's something you need to wear for whatever reason, if it's related to your needs, especially your medical needs, that should be an iterative process that is brought up through. I'm going to say this because I know it can be an area of challenge. Anytime an employee brings up a need that is related to a medical need or a disability need, if you don't have a very clear policy on handling that, that is the time to bring in an HR specialist, talk to your library system, talk to someone who has worked through accommodation questions before. You have one chance to get it right. And if it isn't handled properly, it can be really detrimental both to the employer-employee relationship, and you could have some compliance issues. So it's just not don't wing ADA stuff until you've gone through it several times and your institution has a really good policy that that will have your back.
We have a request for a dress code policy sample.
Oh,
they're updating their personnel manual and want to make it fair and equitable.
You know what we can do? Let's make it, Brian, if you can make a note, we'll send that out. We'll send that out to Carolyn and that can get sent out along with the questions that we're going to answer. I saw a good one the other day, so yes, I'll be stealing that from an undisclosed client. So, but it's public information after that. So there you go.
I am
Anything?
not seeing any further.
All right. Well, probably it was a little overwhelming. So I think we're good. If we're good, that's wonderful. I just want to encourage everyone out there who, if you're still with us, have a great weekend. Stay strong. The work you do is so important. We're going to be sending out more information on certain things. And I just want to thank you for your attention and your contribution today, and for as always, for your service. And many, many thanks to Empire State Library Network for having us here today, and to Carolyn and Sue and the teams at ESLN for making this happen, and to my own team. So thank you, everybody. I'm out.